Okay, let's paint a picture here. You're in a doctor's office, maybe facing a pretty significant medical crossroads. Could be
Yeah.
your own health,
Right.
or maybe you're trying to help a loved one who can't speak for themselves.
Yeah, happens all the time.
So in those really crucial moments, what principles are actually guiding the decisions? And who ultimately has the authority to make that call?
Well, what's fascinating here, I think, is that these really deeply personal situations, they're actually handled within a pretty well-defined framework. Ethical considerations, legal rules.
So it's not just about gut feeling.
Not at all. There's a whole system, really, designed to help navigate these challenging healthcare decisions.
Exactly. And that's really what we're diving into today. This deep dive is all about exploring that ethical and legal landscape around healthcare choices, specifically here in Canada.
Right?
We've pulled together info from, key ethical guidelines, the legal frameworks that apply, definitions of important medical terms. Our goal really is to just bring some clarity to things like consent, confidentiality, end-of-life care, reproductive rights too.
And it's probably more relevant than, you might initially think. Just consider this for a second. What if a substitute decision maker, an SDM, makes a choice that you feel fundamentally goes against what's right for you or your loved one?
Okay.
This is where it gets really interesting. There are specific conditions where a physician not only can, but you could argue should, challenge that decision.
Wow. Okay.
Yeah, we'll definitely be unpacking what those conditions actually are.
Okay. Let's start with maybe a foundational piece.
Yeah.
Confidentiality. We hear doctor-patient confidentiality thrown around a lot. But what does it, practically mean?
Well, at its core, confidentiality is really the duty, the obligation for healthcare providers to protect your personal health information.
Right.
It's totally fundamental to the trust, that relationship between a patient and their healthcare team.
And building right on that trust is the absolute need for consent for any medical treatment. Seems obvious, maybe, but it's a really critical legal line, isn't it?
Oh, absolutely. In fact, providing treatment without informed consent, that isn't just, ethically iffy. It's legally considered a civil wrong, like battery in some cases.
Wow.
It really shows how seriously the legal system takes your autonomy, your right to decide about your own body.
Okay, so informed consent, it's got to be more than just, signing a form on the way in, right? There's a real understanding process.
Definitely.
The info we looked at highlights a test for understanding and a test for appreciation. Can you break those down a bit?
Sure. So the test for understanding basically checks if the patient can, grasp the information they've been given. Can they explain it back in their own words?
Like what the treatment is, what it involves.
Exactly. What it involves, potential outcomes, that sort of thing. Then the test for appreciation, that goes a step further. It looks at whether the patient can explain how that information actually applies to them, to their own situation. Do they get the personal implications for their life, their well-being? So someone might understand, say, the mechanics of a surgery, that's the understanding part,
Right.
but maybe they don't truly appreciate how a potential complication could, affect their ability to live independently. That's the appreciation piece.
Got it. So it's not just knowing the facts, it's understanding what they mean for you.
Yeah.
Okay, so what happens if someone actually can't give consent themselves?
Yeah.
That's where this idea of a substitute decision maker, an SDM, comes in.
Precisely. Yeah. An SDM is someone who is legally authorized to make healthcare decisions for someone who's been deemed incapable of doing it themselves.
And how is that person chosen? Is it automatic?
Well, the system usually has an automatic order, a hierarchy. Generally, it starts with the closest living relative by blood, marriage, or adoption. The thinking there is, prioritize those who likely know the person best.
But that automatic list, it isn't always the final answer, is it? I think our notes mentioned someone can be legally appointed.
That's exactly right. Through a formal legal process, like a power of attorney for personal care, you can actually designate someone specific to be your SDM. And that appointed person would then have the authority, potentially overriding who's next on that automatic list.
Okay. Now, when these SDMs are making decisions, they can't just do whatever they personally think is best, can they? There are rules they have to follow.
Absolutely not. They're bound by specific principles. The number one guiding principle is they must first try to act according to any wishes the person expressed when they were capable.
So talking about your wishes beforehand is really key.
Hugely important. Make your wishes known. Write them down. Talk about them.
Okay, and what if those wishes just aren't known? Or they never expressed anything specific.
Right. In that case, the SDM has to act in the patient's best interest, and that's not just a vague idea.
Yeah.
No, there are specific factors they have to consider. Things like the values and beliefs the patient held when they were capable, the likelihood of their well-being improving with or without the treatment being proposed,
Okay.
and importantly, a careful weighing of the expected benefits versus the potential risks or harms.
A balancing act.
Very much so. And they also need to check if there's maybe a less intrusive treatment option available that could be equally beneficial.
It sounds like a very deliberate, thoughtful process they have to go through.
Yeah.
But you mentioned earlier, and this was really interesting, that a physician can actually challenge an SDM's decision. When would that happen?
Yes, and this is such a crucial point. If the physician has a genuine, reasonable belief that the SDM is not following those principles we just talked about.
Like ignoring known wishes.
Exactly. Or maybe disregarding the patient's known values, or making a decision that just clearly seems not in the patient's best medical interest based on all those factors.
And what?
Then the physician doesn't just have the right, arguably, they have a professional responsibility to challenge that decision. It acts as a really important safeguard for the patient, for the person who can't advocate for themselves at that moment.
Okay, that's a really powerful check and balance in the system. Good to know. Let's shift gears a bit. Let's move into another area that often brings up complex questions: reproductive issues.
Right.
Specifically, the Canadian Medical Association, the CMA, has a definition for induced abortion. What is that definition?
Yeah, according to the CMA, an induced abortion is the active termination of a pregnancy before fetal viability.
Okay, and viability has a definition too.
Generally, yeah. It's usually defined as when the fetus weighs more than 500 grams or has reached more than 20 weeks of gestational age. Those are the typical benchmarks.
Got it. And legally, what's the status of abortion in Canada? Quite different from some other places, right?
That's correct. It's quite distinct. In Canada, there's actually no criminal law that prohibits abortion. It's been decriminalized since the Morgenthaler decision in '88.
So it's treated purely as a healthcare matter.
Essentially, yes.
Yeah.
It's considered a medical and personal decision made between the patient and their healthcare provider and, anyone else the patient chooses to involve. Not a criminal issue.
That's a really key distinction. Now, what about doctors or other medical practitioners who, maybe for personal reasons, don't provide abortions? What are their obligations then?
Right. So if a medical practitioner doesn't provide abortions due to their personal conscientious beliefs, they still have a professional obligation. They're required to provide an effective and timely referral. Meaning they have to connect the patient with another willing and available provider, or at least provide information on how to access services without causing unnecessary delay. The patient's access to care is paramount.
Okay. And we also looked at information about abortions later in pregnancy, second and third trimester. Obviously, these are more complex situations. Under what kinds of circumstances might these be considered?
Yeah, while still legal, abortions later in pregnancy generally happen under more specific, often serious circumstances.
Such as?
Often things like significant risks to the pregnant person's physical or mental health.
No.
Or if, sadly, the fetus has died in utero, a stillbirth. Or if the fetus is diagnosed with a major, irreversible condition where the prognosis after birth is extremely poor.
Like an encephaly, maybe?
Exactly. Conditions like anencephaly are a common example. But it's important to remember these are common reasons, but maybe not the only reasons they might be sought or performed.
Understood. Okay, let's move on to genetics. We looked at the Genetic Non-Discrimination Act. What was the main point of that legislation?
Yes, GIANA. That act, from 2017, is basically designed to protect people, to protect individuals from being discriminated against based on the results of their genetic tests.
Discrimination in what sense? Like insurance or employment?
Primarily, yes. Preventing companies or employers from requiring genetic tests or using the results against someone, with some specific exceptions. It's really important as genetic testing becomes more common and more powerful.
And I assume, just like any other medical test or procedure, you need informed consent for genetic testing.
Oh, absolutely. 100%. Informed consent is fundamental before any genetic test is done.
So people need to understand what the test is for.
Exactly. What it involves, what kinds of information it might uncover sometimes unexpectedly, and how that information could potentially be used or misused.
Right.
And related to that, physicians also have a responsibility to inform patients about the availability of relevant prenatal genetic testing options, if that's something the patient might want to consider during a pregnancy.
Now, here's a really tricky ethical spot that came up. The idea of sharing genetic information with family members. even if it means potentially breaching patient confidentiality. When could that possibly be okay?
Oof. Yeah, this is an extremely complex area, ethically and legally.
Yeah.
And the bar is very, very high.
I bet.
Generally, you need the patient's explicit consent to share their genetic information with anyone, including family. Full stop. However,
There's a however.
there's a narrow however.
Or
In very specific, rare situations, a physician might be permitted to disclose this information without consent if there's a clear, identifiable, imminent risk of serious bodily harm or death to a specific family member.
Okay.
And if that harm could potentially be prevented if the family member knew the genetic risk and could take action, like screening or preventative treatment.
So not for just any genetic condition.
Definitely not. It generally doesn't apply to, say, chronic conditions or risks that aren't immediate. It's really aimed at acute, preventable, life-threatening situations.
And even then,
Even then, given the huge ethical weight and legal risks, the strong recommendation is always to seek legal counsel and consult with bioethics experts before ever considering such a breach of confidentiality. It's really a last resort in extreme circumstances.
that makes sense. It really highlights that tension, doesn't it, between one person's privacy and maybe preventing serious harm to someone else. Okay, let's turn now to medical assistance in dying. MAID. This has brought huge changes in Canada, legally and ethically.
Oh, absolutely. A massive shift. The whole legal framework has evolved significantly. It really started with the Supreme Court's Carter versus Canada decision back in 2015.
Right, that struck down the old laws.
Exactly. It found the criminal ban on assisted suicide unconstitutional in certain circumstances. That led to the government introducing Bill C-14 in 2016.
And that created the rules.
That created the legal exemptions in the criminal code, allowing for MAID under specific conditions. And then more recently, Bill C-39 in 2023 put a temporary pause on eligibility for people whose only underlying medical condition is a mental illness.
And that pause is still in effect.
As of our recording, yes. The current plan is for that pause to end on March 17th, 2024, but these things can sometimes change, so it's worth keeping an eye on.
Okay, so under the current legislation, setting aside the mental health exclusion for now, who is eligible for MAID?
Right. The criteria are quite specific. First, you have to be eligible for publicly funded health services in Canada, covered by provincial or territorial health insurance.
Okay, age, capacity.
Got to be at least 18 years old. And crucially, you must be capable of making your own decisions about your health. You need capacity for informed consent right up until the moment MAID is provided.
And the medical condition itself.
You have to have what's called a grievous and irremediable medical condition.
Yeah.
That means an advanced and irreversible illness, disease, or disability.
Grievous and irremediable, okay.
And that condition must be causing you enduring physical or psychological suffering that is intolerable to you and that cannot be relieved under conditions you consider acceptable.
Intolerable suffering from the patient's perspective.
Exactly. And one key change from the original legislation is that your natural death does not need to be reasonably foreseeable anymore. That requirement was removed by Bill C-7.
Ah, that's a significant change.
Okay.
Our info touches on the MAID process itself, but maybe we don't need to get into all the procedural steps today.
Probably not. It's quite detailed. But understanding the eligibility is key.
Agreed. Okay, let's shift again to a different aspect of end of life. What are a doctor's responsibilities when a patient dies? Besides, the obvious care aspect.
Well, a primary legal responsibility is to complete a medical certificate of death. But it's not always just filling out that form. There are specific situations laid out in the Coroners Act provincial legislation, usually similar across provinces. The one we looked at was Ontario's from 1990, where a physician must notify a coroner or the police.
Okay, what kind of situations trigger that notification? Seems important.
Yeah, it is. It includes death that happened because of violence, negligence, misconduct, misadventure, or malpractice. Basically, unnatural or potentially suspicious causes.
Okay, anything else?
Yes. Also, any death during pregnancy or related to pregnancy, deaths that are sudden and unexpected, deaths from a disease that wasn't being treated by a qualified doctor, deaths that seem to be from any cause other than disease, deaths under suspicious circumstances generally, and importantly, deaths that result from MAID must also be reported to the coroner.
MAID deaths too. Interesting.
Yes, it's part of the oversight process. The coroner then investigates these reported deaths.
Okay, that makes sense. It really shows there are significant legal and procedural steps even after death occurs. Now, our information also talked about planning ahead advanced care planning. specifically living wills and durable power of attorney for healthcare. Can you sort of clarify the difference and how they work together?
Yeah, absolutely. It's helpful to think of a living will, sometimes called an advance directive, as sort of your plan A.
Plan A.
Yeah, it's a written document where you outline your wishes for medical care if there's an emergency or if you become unable to make decisions later on.
What kinds of things would you put in it?
Things like your views on resuscitation, CPR, what level of quality of life you find acceptable, specific end-of-life treatments you would want, or, just as importantly, treatments you would refuse.
So being specific is good.
Very good. The more specific you can be in your living will, the clearer your instructions are for your healthcare team and family.
Okay, so that's plan A. What's plan B then? The durable power of attorney.
Exactly. The durable power of attorney for healthcare, or sometimes called a healthcare proxy or representative depending on the province, that's your plan B.
Why plan B?
Because it's a legal document where you appoint a specific person, your attorney or proxy, who you trust to make medical decisions for you if you can't. This is crucial for situations your living will might not cover.
Because you can't predict everything.
Precisely. Even a really detailed living will can't anticipate every single possible medical scenario. So having someone appointed to make decisions in those gray areas or unforeseen circumstances is really vital.
Okay, so you have the living will, plan A, with specific instructions, and the power of attorney, plan B, appointing a person. What if there's a conflict? Like the living will says one thing, and the person appointed wants to do something else.
Good question. In case of a direct conflict on something specifically addressed in your living will takes precedence.
My written wishes rule.
Exactly. Your direct wishes, as written when you were capable, generally override your appointed decision maker on that specific point. The attorney's role is really to make decisions on things not covered by the living will, or if the living will is maybe unclear in the current situation.
Got it. That makes sense.
But given how important these documents are and how complex the legal side can be, getting advice from an estate planning lawyer who understands healthcare directives is really, really advisable.
Yeah, definitely sounds like something you want to get right.
Yeah.
Okay, one last concept we touched on briefly. Conscientious objection in healthcare. What does that mean?
Right. Conscientious objection basically refers to the right that individual healthcare providers might have, depending on regulations and professional guidelines, to refuse to participate in certain specific medical procedures.
Like abortion or MAID, maybe?
Exactly. Those are common examples. Based on their deeply held moral or religious beliefs, it adds, another layer of ethical complexity to how healthcare is delivered. But as we discussed with abortion referrals, it usually comes with obligations, too.
Right, the duty to refer. Okay. So wrapping this all up, we've covered a lot of ground today. It's clear the whole landscape of healthcare decisions is incredibly complex, isn't it?
Absolutely. It's this real mesh of personal autonomy, the absolute need for informed consent, detailed legal frameworks, and then these really sensitive, often difficult realities around end-of-life care.
Yeah, what's really insightful, I think, is seeing how all these different pieces, ethics, law, personal wishes, medical judgment, they all connect and interact.
And they're constantly trying to find that balance, right, between individual rights and the sort of broader legal and ethical duties within the whole healthcare system.
And understanding these principles,
Right.
it's not just like an academic thing. It feels essential for all of us, as we navigate our own healthcare or help support the people we love with their decisions.
Couldn't agree more. It's practical knowledge everyone should have some grasp of.
Definitely. And maybe on that note, here's a final thought for you, our listener, to maybe mull over. Given all the intricacies we've talked about today, especially around consent and substitute decision makers, what do you think are the absolute most important conversations that people should be having with their loved ones right now about their wishes for future healthcare?
That's a really powerful question to leave people with.
Yeah, it feels like a really vital area for reflection, especially as you said, healthcare ethics and the laws around it are always evolving. Things change.
They certainly do. Constant evolution.